I thank the delegation of Slovenia for its presentation. I invite the next participating delegation, Sudan, to make its oral statement before the court and call upon Mr. Marwan Khair to take the floor.
Mr. President, distinguished members of the court, it's my honor and privilege to address the International Court of Justice on behalf of the Republic of the Sudan. I express gratitude to this court for extending the opportunity for my country's participation in these advisory proceedings on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. The Sudan is present here today, owing to the profound significance of these proceedings in the context of realizing the inalienable right of the Palestinian people to self-determination. This matter has persisted on the United Nations agenda for several decades. The dire circumstances prevailing in the occupied Palestinian territory over the past decades, compounded by the current severe humanitarian crisis in Gaza Strip, underscore the profound jeopardy facing the fundamental rights of all people in the Middle East, particularly the Palestinians. Therefore, these oral proceedings assume critical importance in persuading the court to exercise its jurisdiction and accept this request for an advisory opinion. The Sudan contains that such a stand by the principal judicial organ of the United Nations would convey a definitive message to both Israel and Palestine, urging them to redouble their efforts in achieving peace and security for the mutual benefit for their peoples. Moreover, the Sudan maintained the perspective that in giving this advisory opinion, the court would assume a crucial role in fostering justice, peace, and security, not only in Israel and Palestine, but also in the Middle East and beyond. Mr. President, in accordance with the rules of court, we will address the statement specifically to the issue that, from the perspective of the Sudan, remains a point of contention among the participants in these proceedings, whether or not the court should give the requested advisory opinion. The statement will be as succinct as possible within the limits of what is necessary for adequate presentation of the Sudan's contention at this hearing. Mr. President, I respectfully invite you to give the floor to Professor Raimondo, who will proceed with the delivery of this oral statement. Thank you, Mr. President. Thank you, members of the court.
I thank Mr. Khair. I now give the floor to Mr. Fabian Raimondo. You have the floor, sir.
Mr. President, distinguished members of the court, it is my privilege and pleasure to stand before the International Court of Justice today to address the issues of jurisdiction and admissibility of this request for an advisory opinion. The articulation of objections to the admissibility of a request for an advisory opinion from the General Assembly is not an uncommon occurrence in proceedings before this court. Nevertheless, the court has consistently dismissed such objections. In the subsequent discussion, I shall initially recall the consistent jurisprudence of this court on the issues of jurisdiction and admissibility. It is within this body of jurisprudence that the court can find the resolution to the objections raised concerning the admissibility of the current request for an advisory opinion. As pointed out by this court in the Chagos advisory opinion, I quote, "When the court is seized of a request for an advisory opinion, it must first consider whether it has jurisdiction to give the opinion requested, and, if so, whether there is any reason why the court should, in the exercise of its discretion, decline to answer the request," unquote. The jurisdiction of this court to provide an advisory opinion stems from Article 65, paragraph 1 of its statute. This article provides that the court may give an advisory opinion on any legal question upon the request of any body authorized by or in accordance with the Charter of the United Nations to make such a request. The General Assembly has the authority to request an advisory opinion according to Article 96, paragraph 1 of the Charter of the United Nations. And this article stipulates that the General Assembly has the power to ask the International Court of Justice to provide an advisory opinion on any legal question. In these proceedings, the court is first asked to determine the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem, and from its adoption of related discriminatory legislation and measures. Next, the court is asked how said policies and practices affect the legal status of the occupation and what legal consequences ensue for all states and the United Nations from this status. Mr. President, members of the court, it is evident that these questions concern the legal consequences of violations of international law that have been recognized as such by the Security Council and the General Assembly, among other United Nations organs and bodies, as well as to the legal status of the occupation in view of those violations and the legal consequences of its illegality. The General Assembly requests the Court to answer these questions in accordance with, inter alia, the rules and principles of international law, international humanitarian law, and international human rights law. For these reasons, the Sudan believes that the request has been made in accordance with the Charter and that the questions submitted to the Court are legal in character. I shall now proceed to the issue of the admissibility of the request. As recalled by the Court in the Chagos advisory opinion, I quote, "The fact that the Court has jurisdiction does not mean, however, that it is obliged to exercise it," unquote. According to consistent jurisprudence of this Court, the discretion whether or not to respond to a request for an advisory opinion exists to safeguard the judicial function of the Court as the principal judicial organ of the United Nations. However, the Court is aware that its reply to a request, I quote, represents its participation in the organization and, in principle, should not be reviewed, end of quote. It is an established jurisprudential principle that this Court may decline to respond to a request for an advisory opinion falling within its jurisdiction only in the presence of compelling reasons. The pertinent query at hand is whether there exists any compelling reason for this Court to decline to respond to the request referred by the General Assembly. Some participants in these proceedings have indeed alleged the existence of such reasons. The grounds most frequently invoked in these proceedings include, firstly, the contention that providing the opinion would prejudice the negotiation process between the parties involved in the underlying dispute. Secondly, the argument that admitting the request will be incompatible with the principle of consent in judicial settlement. And thirdly, the alleged prejudicial nature of the underlying questions and the lack of sufficient factual inquiry. I will now examine the first ground. This ground was raised by Canada, Hungary, Israel, Italy, and Zambia, among others. Thus, for example, in the opinion of Italy, I quote, "An advisory opinion by the Court might reduce the flexibility of the parties in dealing with present circumstances and long-term prospects, and therefore would not contribute to move the process closer to a mutually agreed solution," end of quote. This constitutes a type of argument that this Court has previously considered in other advisory proceedings. For example, in the nuclear weapons advisory opinion, the Court noted that concerns were raised about the potential negative impact of its response on disarmament negotiations. The Court acknowledged that regardless of its conclusions, they would introduce an additional aspect to the negotiations. However, the court stated that the ultimate effect of its opinion is a matter of appreciation and cannot be seen as a compelling reason to refuse exercising its jurisdiction. This jurisprudential principle was confirmed by this court in the advisory opinion on the wall. There is an additional, pivotal aspect to address in this context. The two questions central to the ongoing advisory proceedings pertain to the existing conditions in the occupied Palestinian territory. The court is not tasked with determining the content of a final settlement or the precise boundaries of the Palestinian state. Essentially, the request seeks the court to provide an authoritative legal opinion on the current legal ramifications of the practices and policies of Israel referred to in the request. The advisory opinion is expected to bear relevance to extant queries regarding legal status and its associated consequences. Such clarification holds the potential to significantly contribute to establishing the groundwork for a prospective negotiated resolution of the underlying conflict, rather than to endanger the established framework for negotiations that have been suspended for several years now. Hence, the Sudan believes that this does not constitute a compelling reason to decline responding to the request. I shall now address the second ground, the contention that the opinion would circumvent the principle of consent in judicial settlement. This ground was raised by Canada, Fiji, Hungary, Israel, and the United Kingdom, among other participants. For example, Canada objects that, I quote, "It is Canada's understanding that Israel, which has a direct interest in this case, has not provided consent for the ICJ to desist of this matter." End of quote. It is well-established jurisprudence of this court that the lack of consent to the court's contentious jurisdiction by interested states does not impact the court's jurisdiction to render an advisory opinion. This rationale is exemplified by instances such as when the court gave its advisory opinion on Western Sahara, even in the absence of Spain's consent to the request. When it delivered the advisory opinion on the wall, despite Israel not providing consent. And when it issued the Chagos advisory opinion, notwithstanding the absence of consent from the United Kingdom. In each of these instances, the court gave its opinions, even though the request concerned the responsibility of particular states. As this court said in Western Sahara, I quote, "In the present case, Spain is a member of the United Nations and has accepted the provisions of the Charter and Statute. it has thereby, in general, given its consent to the exercise by the court of its advisory jurisdiction, unquote. In the Sudan's view, the same rationale applies in the current advisory proceedings. The General Assembly has consistently played a crucial role in matters concerning Palestine, as evident from the documentation presented in the Secretary General's dossier before this court. The Palestinian people are yet to realize their right to self-determination, a fact that no state can plausibly contest. Therefore, the Sudan believes that the objection to the General Assembly's exercise of its competence in the realm of self-determination and its consideration of the situation in Palestine is unpersuasive. I shall now address the final ground, the allegedly prejudicial nature of the questions posed by the General Assembly and the lack of appropriate factual inquiry. This ground was raised by Israel in the following terms, I quote, "The tendentious questions placed before the court not only distort the factual reality, they fundamentally misrepresent the legal reality as well." End of quote. In the same vein, another participant in the proceedings, the United Kingdom, posits that the request is inadmissible on the ground that, I quote, "the court cannot be confident that it will have a complete or accurate evidential picture before it." End of quote. Further, in this regard, the United Kingdom contends that, I quote again, "insofar as Israel does not participate in the advisory proceedings by furnishing evidence relevant to the request, the court will lack material explaining the Israeli side of the picture." End of quote. Nevertheless, it is imperative to recall that in the overwhelming majority, if not all, of the opinions rendered by this court, reliance on public information derived, for instance, from United Nations organs or specialized agencies has been a standard practice. In part 2 of the dossier of materials before this court, there are many reports of competent United Nations bodies, such as the Special Rapporteur on the Situation of Human Rights in the OPT, the High Commissioner for Human Rights, and several human rights treaty bodies. Hence, in the Sudan's view, all these reports provide the court with sufficient information on the facts before it to give the requested opinion. Mr. President, members of the court, I express my gratitude for your attentive consideration, and I respectfully invite you to request Mr. Heir to deliver the concluding remarks of the oral statement on behalf of the Sudan.
I thank Mr. Raimondo. I now give the floor back to Mr. Khair. You have the floor, sir.
Mr. President, distinguished members of the court, I wish to emphasize the great significance of the right of peoples to self-determination. In advisory proceedings conducted before this court, wherein the exercise of this right was a pivotal concern, the court's opinion emerged out of fundamental elements shaping the legal framework for resolving the underlying disputes, such as the one concerning Namibia. If only we had a comparable equivalent for Palestine. The successful resolution of the protracted dispute surrendering Namibia can be largely attributed to the court's judicial task. It's respectfully suggested that you should persist in fulfilling that role in the present advisory proceedings. In the light of the foregoing, the Sudan concludes that the court not only has jurisdiction to give the advisory opinion requested by the General Assembly, but also that there is no compelling reason for this court to use its discretionary power not to give the opinion. Thank you, Mr. President. Thank you, members of the court.